All right, welcome to our channel. Today, I'd like to discuss whether you can get a Section 8 voucher or live in federally assisted housing after you've had an eviction. So, we're going to talk about that a little bit. But before we start, my name is Jay. I'm the owner of Section8Consulting.com, and I've worked with clients for around 26 years. So, I've seen tens, if not thousands, of cases where we've dealt with evictions, but do understand evictions, whether you before you attempt to get housing or after you've already had it, it really depends on the specific circumstance of what happened. So let's talk about what happens and how the PHA, HUD, and other federal regulations affect that. I'm going to bring in notes for you guys that are slow learners, or maybe you find I talk a little too quick, and that way you can reference these notes in the comments section and also the description of the video. Okay. So, yes, a person with an eviction does not automatically or permanently disqualify somebody from receiving Section 8 housing or the Housing Choice Voucher, but it strongly depends on when the eviction has occurred, why the person was evicted, how long ago it really happened, whether money is owed to the housing authority, and whether the local housing authority's administrative plan will allow it. And also, if you look at the application, whether or not you can satisfy the landlord's individual pre-screening. So again, if you clear all the bars for dealing with the public housing authority and the voucher, doesn't necessarily mean that an independent landlord is necessarily going to want to approve your application. Okay, so moving on from there, let's talk about the different eviction and eligibility effects depending on circumstance. So, private landlord eviction for unpaid rent. Well, generally not an automatic federal disqualification. You got a private eviction from for committing property damage or a serious lease violation. The housing authority may consider it under its local screening policy, which is typically found in their administrative plan. If you want to know how to get that administrative plan so you can look at these rules, you can do a Freedom of Information Act or FOIA and fill out that request and then mail it to them or email it or send it in and ask them for a digital copy of their administrative plan. That will allow you to be able to kind of look at how they might deal with these circumstances as well. So, an eviction from federally assisted housing within the last 5 years, the housing authority may deny admission, but denial is generally considered discretionary. Let me make it undiscretionary for you. If you've been evicted the last 5 years, they're not going to be interested in discussing anything with you. Okay, only under rare circumstances. Moving on from there, an eviction from federally assisted housing generally requires a 3-year probation from the eviction date, subject to limited exceptions. And those exceptions, again, can be found in the administrative plan. So, an eviction connected to domestic violence, dating violence, assault, or otherwise stalking. Under those circumstances, it falls under VAWA protections and may prevent the eviction from being used against the survivor. In other words, you could argue under VAWA rules and policies at the federal level that if you are a domestic violence survivor, that the eviction may not be counted in any way towards you being denied housing or a voucher, okay, on the basis of you receiving an eviction for that purpose. And last but least, the eviction while receiving HCB voucher for a serious lease violation. The housing authority generally must terminate the family's voucher assistance. So, if you violate the terms of your HAP contract or the lease in which you've engaged with the landlord, then you're under a contentious agreement, a contract. If you violate those rules, then you can forget about it. Okay. Moving on from there, private eviction does not automatically bar Section 8. An eviction from regular privately rented apartment, especially one caused by unpaid rent, job loss, or other financial hardship, is not in the self-mandatory federal reason to deny an HCV application, meaning Housing Choice Voucher. However, the Housing Authority may screen participants for mental history, suitability of its screening standards, or contained in the administrative plan, as I mentioned before. And the housing authority may consider matters such as repeated failure to pay rent, serious repeated lease violations, property damage, disturbances and threats to other residents, fraud involving federal housing program, and criminal activity connected to the eviction, of course. To look at the exact evidence considered in differentiating the rules and policies under HUD, I'm going to advise you to seek out this link here, which will be posted in the comment section and the description, which will be the HUD Housing Choice Voucher Guidebook. It's a very extremely useful tool, not just for evictions in consideration of this, but all rules and policies. Okay. Number two, eviction from a federally assisted housing. Well, the housing authority may deny an application if the housing member was evicted from federally assisted housing during the previous 5 years. This is permitted ground for denial and not an automatic 5 year federal ban on every case, but in most cases, actually. The PHA may consider mitigating circumstances, including the seriousness of the violation, how much time has passed, which household member may be responsible, whether the responsible person is still in the household, the effect of the denial and innocent family members, rehabilitation or improved rental history, circumstances related to the household member's disability as well. And the PHA may also require a responsible household member be excluded instead of denying assistance to the entire family. Now, you want to look deeper into that, you can go to Title 24, Code of Federal Regulation 982.552. Next, we're going to move to drug related evictions, have a special rule, of course. And if a household member has been evicted from federally assisted housing for a drug related crime activity, the PHA generally must prohibit admission for 3 years beginning the date of the eviction. This can sometimes lead up to 5, by the way. A PHA or public housing authority may admit the family sooner if it determines the following reasons. The responsible household member has successfully completed the PHA approved supervised drug rehabilitation program, or the circumstances causing the eviction no longer exists. For example, the responsible person died or is incarcerated or permanently removed from the household. Do also keep in mind separate mandatory restrictions apply to anyone subject to a lifetime state sex offender registration or anyone convicted of manufacturing methamphetamines on a federally assisted housing premise. And that can be found on Title 24, 982.553. And just to be clear, guys, if you're SO or a sex offender or you have any type of conviction on your record related to methamphetamines, you can forget about it. They're not going to deal with you, okay? Not today, not tomorrow, not ever, unless they change that at the congressional level. Moving on from there, number 4, money owed to the housing authority can cause a denial. So a PHA deny assistance if the family currently owes rents and other amounts to the housing authority in connection with Section 8 housing or public housing. This could include money that the PHA paid to the former landlord for rents, damages, or other obligations. Possible solutions may include paying the verified balance, disputing the incorrect balance, requesting an itemized accounting, negotiating a repayment agreement if the PHA permits one, showing that the debt was discharged or is legally unenforceable, providing proof that another household member, not the applicant, was responsible. And so repayment agreement is not automatically required. The PHA has the discretion over whether to offer one and what terms it might accept. And that's strongly going to be dictated by, again, the administrative plan, which can be requested through a Freedom of Information Act or FOIA directly through your public housing authority. That's a lot of words, isn't it? My jaw's getting tired. Number 6, the voucher approval does not guarantee landlord approval. There are 2 separate decisions. Number 1, the housing authority determines whether the family qualifies for a voucher. Number 2 would be the property owner determines whether to approve the family for a particular unit. Federal regulations make the owner responsible for tenant screening. An owner may review the rental history and property care, lease compliance, disturbances, and other lawful screening information. Therefore, someone may receive a voucher but still have difficulty finding a landlord who will accept their eviction history. And you can learn more about that under Title 24, 982.307. State and local laws may limit how landlords use older, dismissed, sealed, or eviction filing records. So here's a few recommended steps before applying, and this will be the almost the end of the video, obviously. So the recommendation to obtain and complete eviction court record, including the complaint, judgment, dismissal, settlement, and payment history. And number 2, to determine whether the eviction involved private housing or federally assisted housing. Number 3, request a copy of the PHA administrative plan and review its admission and tenant screening provisions. Number 4, obtain a written confirmation of any balance alleged owed to the PHA, correct inaccurate eviction credit and tenant screening records, prepare evidence explaining the circumstances, and show present housing stability references as well as disability related circumstances or VA, WA protections when applicable. Never conceal a eviction when when the application asks for it. A false statement can create a separate fraud or misrepresentation issue. And so, as you can see here, I'm going to post some additional notes below this, which will be in lieu of denials of these applications on the basis of eviction, which you can take a look at after the video. Um, just to be clear before I go, guys, I make videos on Tuesdays, Thursdays, and Sundays around 11 a.m. Central Standard Time. Those are live videos. All the rest are going to be pre-records like the one here today. I've enjoyed having you guys and look forward to speaking with you in some of our live videos. All right. Have a great week. Bye for now.